Hey everyone, welcome back to Roots and Rights, Securing Tomorrow. I'm your host, Attorney Greg Robinson, and if you're tuning in for the first time, or if you've been following along on our journey from blended families to life insurance strategies, today's episode might just hit closest to home. Because, honestly, nothing gets more personal than talking about who will care for your children if something happens to you. Now, yeah, I know, nobody wants to think about that scenario, but it's one of the most loving things you can do for your family. Let's start with the basics. What exactly does a guardian do? A guardian steps into your shoes, both legally and practically, if for any reason you and your co-parent, or whoever has legal custody, aren't able to continue. They're responsible for your child's upbringing, their health, education, you name it, until the child turns 18, or in some states, 19. I always say, don't get hung up on the technicalities. Think of it as someone making 1,000 daily decisions on your child's behalf. Imagine, who will your kids turn to for guidance on their first heartbreak? Or, I don't know, negotiating their way through that outrageous math homework. Ugh, I don't miss that part. Now, the legal process for naming a guardian does differ a bit state to state. In every case, you do this in your will. That's the gold standard. If you skip this step, a judge will decide who steps up as guardian. And look, the court's decision might not always match your wishes or your family's values. There could be competing relatives or someone you'd never pick. So it's a risk you shouldn't take lightly. I mean, I've seen cases where parents just assumed their families would figure it out. And well, what happened was confusion, court delays, and some really hurt feelings. So the lesson here? Name your guardian. On paper. Have that talk, even if it's tough. It's way better for your kids, and believe me, for your extended family too. Now, one thing I've learned, both as a lawyer and as a parent, is that families are messy. Sometimes beautifully so, sometimes less so. When it comes to guardianship, it's not uncommon for folks to hit some rough patches. You might worry, what if my brother disagrees with my choice? What if my parents are offended? Or, how do I deal with a situation where siblings both want the role? Some families try to split the baby, so to speak, appointing co-guardians. This can work, but honestly, it's tricky. Let's say you name your sister and your best friend as guardians together. What happens when they see things differently? I've seen real cases where this led to gridlock, and the court ended up getting involved anyway. In general, a single guardian gives you more certainty. But here's the caveat. Sometimes it's the only way to keep peace. You know your people better than any attorney, including me. I always recommend writing what's called a letter of explanation, or sometimes we use the term letter of intent. This isn't a binding legal doc, but it's a powerful tool for easing tensions before they get heated. You lay out your reasons for your guardian choice, maybe your hopes for your children's upbringing, or just clarifying that your decision isn't meant to slight anyone. Communication up front can diffuse drama before it starts. So as we talked about in our episode on blended families, clear communication and naming intentional decision makers is the real MVP in estate planning. And that definitely holds true when it comes to guardianship. All right. Let's talk documents and practical steps, because this is where a lot of folks get tripped up. To legally name a guardian, you've got to get it in writing in your will, plain and simple. But don't stop there. I like to see families pair their will with a testamentary trust. This lets you spell out how assets for your children are managed until they come of age. That's huge because it keeps things out of court and avoids putting a pile of money into a teenager's hands. Trust me, that never ends well. Add in powers of attorney for health and finances for yourselves, and you're really covering your bases. And, this is key, keep all those documents current. If your life changes, a new baby, a move, a major falling out, update your plan. I mean, I'll admit, even as an estate attorney, I let ours get dusty once or twice between moves. It happens. Communicate your plan, not just with your chosen guardian, but with your broader family. You don't have to host a whole family town hall, but make sure folks know where the documents are and, at a minimum, who you've chosen. Directness really protects everyone down the line. Legal documents do the heavy lifting, but open conversations are what smooth the path. I had a client, we'll call her Ms. Thompson, who did just this. She was nervous about naming a non-family guardian for her daughter because, well, she feared judgment and family drama. We worked on her will. She wrote a heartfelt letter to her siblings explaining her reasons, and then she sat down with everyone at once. It wasn't easy. There were a few tears, but years later, when that guardianship was needed, the family rallied. There was zero legal drama, just a lot of love, and her daughter's transition was as smooth as you could hope for in a tough time. That, folks, is why we plan. So to wrap things up, naming a guardian is just one piece of building a lasting legacy and protecting what matters most. Estate planning isn't about obsessing over the worst case. It's about giving your family and your kids security no matter what. Thanks for listening. And if today's topic sparked questions or ideas, stay tuned. We'll keep breaking down these issues in future episodes. Until then, take care of yourself and take care of your loved ones.